This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. One last time, this meeting is private, bearing false witness, misrepresentation, and posting inflammatory rhetoric in public forums is forbidden and shall be addressed in an appropriate manner. To eliminate all conflict and false allegations, is there anyone in attendance at tonight's meeting that is a member or agent of any law enforcement agency of a federal, state, province, county, city, or township agency present? This is also for notary, poll workers, school board members, anyone who has signed an oath to the de facto government. Please raise your hand, say your name, and state your position. Perfect, and I'll close with open up with a short prayer. O Holy Father, bless our meeting with eyes to see and ears to hear the messages and information being presented with an open and caring and compassionate heart for all our fellow brothers and sisters, as it shall be done. Take it away, Glenn. Okay, you're muted.
Yep, I was just making some adjustments here. I'm just checking the live stream and make sure that it's coming out good on the live stream. There. So what I was figuring, I also filed a Form 211 with the IRS, which is a whistleblower's form. And so I figured maybe I'd go through that too. This is my first one. So, we'll see. It's like a work in progress, Yep, it's coming out good on YouTube too. All right. So this is in my federal court case lawsuit that I filed. I'm also working on an amended petition, and the Supreme Court, the Court of Appeals ruled in my case, which means that I expect that the Supreme Court will send my petition for a writ of my Rule 11 petition for writ of certiorari back to me. And when they do, then I'll prepare. I have 4 months to prepare my petition for writ of certiorari to the Supreme Court. So I don't see any problem. This is number 6, and so actually probably number 7, depending on how you want to look at it. So we'll see. This one is this case that I filed in Fort Worth over this recent arrest and all this other stuff that went on. And this is the notice of constitutional challenge. I'm challenging the minor estate. I figured, I'm going to set it up. See, the last one I didn't challenge until the end. I figured the judge would honor his oath of office. I should have known better. So I kind of dump on him. I'm starting to dump on him in this, and I'll show you how I'm doing that. But anyway, so this is it's a different judge that's got this one. Matter of fact, it went to that judge. That judge is now the chief judge of the court of the Northern District, and he got the case. So I'm not sure why they always give it to the same guy, but they did, and so he had to recuse himself. So I wasn't even involved in that. He just automatically recused himself, and it's in the hands of another judge. And so, anyways, we'll see how it goes. So this is a notice of constitutional challenge of the minor estate pursuant to Rule 5. Comes now demanding, providing notice to anyone interested that the 1871 Corporation at 16 Stat 419, domiciled in the District of Columbia, the minor estate, 31 CFR 363.6, and the National Bar Foundation all of its subsidiaries are violations of the organic laws, which includes this Constitution for the United States of America, Article 1 and Amendment, which requires Congress shall make no law respecting an establishment of religion. As described in the brief attached, because they all originated from what is now the Vatican, and I can see I have two N's there, so I'll probably fix that. Signed and sealed in red ink on the land under penalty of perjury without the Pope's owned and operated United States. See, I'm getting little digs in here, eh? I, GlennWinningham, House of Fern, demanded sui juris a natural man living in the Republic, and this is where I get some digs in, that fails to be dead or lost at sea, has never been dead or lost at sea, that fails to be a surety or accommodation party for the Pope's minor estate, that fails to represent the Pope's minor estate, and have never knowingly or willingly represented the Pope's minor estate. And do declare that I scribed and read the foregoing facts in accordance with my best first-hand knowledge, such are true, correct, complete, not misleading, the truth, the whole truth, nothing but the truth, before God, angels, and everyone who reads this document as witnesses, and pursuant to your rules of evidence, dated this 30th day of November in the year 2025. And then the signature line, GlennWinningham, House of Fern, sui juris, a living man that fails to be dead or lost at sea, has never been dead or lost at sea. I'm getting little digs in there, right? I've never been dead. The bought and paid for a horse. Anyways, that failed to be a surety for the Pope's minor estate, fails to represent the Pope's minor estate, and have never knowingly or willingly represented the Pope's minor estate, with full responsibility for my actions under Yahweh's laws found in the Holy Bible and no other, with the postal address of General Post Office, zip code exempt, and all the rest of that. And so, and then the certificate of service. I, Meyer, myself, also known as GlennWinningham, House of Fern, a man, a living soul, free inhabitant on the soil of Texas, without the Pope's United States, do hereby certify I'm not a U.S. District of Columbia citizen, 14th Amendment citizen of the Pope's United States, District of Columbia, or other fictitious entity. I'm not a surety or accommodation party for the Pope's minor estate. I'm not dead or lost at sea, have never been dead or lost at sea. I'm not representing the Pope's minor estate, have never knowingly or willfully represented the Pope's minor estate. And I filed the original and a copy of this notice of constitutional challenge, and original with this certificate of service on this day with the court. So we haven't served the lawsuit yet, so I have to get summonses signed, and what happened is the clerk won't sign them until I pay the filing fee, and so we'll go through what I filed in relation to the filing fee, and we'll see what happens. I expect I did it last time, except that I paid the filing fee and then I filed it, and the court actually said that I paid it. So I think I hit a nerve, and I also used the same argument with the Supreme Court, and the problem went away. Anyways, so we'll see. I'll show you the argument. I declare on penalty of perjury under the laws of the United States of America that I failed to be dead or lost at sea. I've never been dead or lost at sea. I failed to be a surety or accommodation party for the Pope's minor estate. I failed to be representing the Pope's minor estate. I've never knowingly or willfully represented the Pope's minor estate, and the foregoing is true and correct without the Pope's United States. Signed and sealed in red ink on the land of Texas this 30th day of November. And then the signature line, GlennWinningham, House of Fern, sui juris, a living man that fails to be dead or lost at sea. I've never been dead or lost at sea. It fails to be a surety of the Pope's minor estate, fails to represent the Pope's minor estate, have never knowingly or willfully represented the Pope's minor estate, sovereign living soul, holder of the office of the people, judicial power citizen by right of blood with full responsibilities for my action under Yahweh's law as found in the Holy Bible. And that other stuff is pretty standard. Anyways, brief in support of the notice of constitutional challenge, the minor estate pursuant to Rule 5. The Pope's ecclesiastical city-states in Italy. The Pope was absolute monarch of a group of ecclesiastical city-states on the Italian peninsula. And this is Waterston Encyclopedia of Commerce and Mercantile Law, 1863, page 582. The Roman or Papal States, stretch across the central part of the Italian peninsula in an oblique direction from the Adriatic to the Mediterranean between Tuscany, Modena, and Lombardy on the northwest and Naples on the southeast. Area 17,822 square miles. Population in 1833, 2,742,000. Capital Rome. Population 153,000. Government and elective monarchy. The Pope, for the time being, the absolute sovereign with the consulting assembly of cardinals. And then Rome, the capital of the Pope's territories of Italy, anciently the Milrus of the Roman Empire. And that's Encyclopedia Britannica, 1773, volume 2, page 632. With the ecclesiastical law being Roman law, which is also called canon law, municipal law, and civil law. The laws of the municipia or dependent states. And this is Encyclopedia Britannica, or a New Dictionary of Arts and Sciences, 1771, volume 2, page 883. Civil or municipal law is that which every sovereign kingdom or state has appropriated to itself. The appellation of municipal was originally confined to the laws of the municipia, or dependent states, but it became by degrees to signify all civil laws without distinction. No sovereign state can subsist without a supreme power, or a right of commanding in the last resort. The supreme power of one age cannot be, therefore, be fettered by enactment of a former age. And canon law is a collection of ecclesiastical rules in the form of the civil. Canon law, or body of canon law, collection of ecclesiastical rules, definitions, and constitutions taken from ancient councils and writings of the fathers of the church, and the ordinances of the popes. This law is modeled according to the form of the civil, contained in 3 particular volumes. That's the New World of Words, English Dictionary, 1720 by Phillips. Civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law, to distinguish it from the law of nature and international law. That's Black's Law Dictionary, 4th Revised Edition, page 312. And Roman and civil or Roman law is also called canon law. The civil or Roman and canon law, though they're not perhaps be deemed parts of our written law, have undoubtedly had the greatest influence of Scotland, okay, and that's the Encyclopedia Britannica, 1771, volume 2, page 883. The Pope's ecclesiastical city-states were annexed to the Kingdom of Italy in the year 1870, and the year prior to Congress's 1871 Ecclesiastical Municipal Corporation, as 16 Stat 419. The formerly Republican leader in southern Italy, Giuseppe Garibaldi, made common cause with the House of Savoy to overthrow the Kingdom of the Two Sicilies, and the people voted in a plebiscite to join Sardinia to form the Kingdom of Italy in 1861. The Papal States and the city of Rome were annexed to the kingdom in 1870, completing the unification of Italy. This kingdom lasted until the aftermath of World War II, when the 1946 Italian institutional referendum ended the monarchy. And are now called the Vatican City and the Holy See, and it continues to this day. This is the Lateran Pact, Article 4, 1929. The sovereignty and exclusive jurisdiction over Vatican City, which Italy recognizes as pertaining to the Holy See, forbid any intervention therein on the part of the Italian government or any other authority other than that of the Holy See, shall be there acknowledged. The Pope's ecclesiastical Roman canon law, Sestike Ius, was brought into the United States with the Pope's 1871 Ecclesiastical Municipal Corporation at 16 Stat 419, because civil law, Roman civil law are convertible phrases, and because municipal law was the laws of the municipia or dependent city-states, papal ecclesiastical city-states. The appellation municipia was originally confined to the laws of the municipia or the dependent states. And that's Encyclopedia Britannica, volume 2, page 883. In the year 1213, King John gave the kingdoms of England and Ireland to Pope Innocent III and agreed to rent them back for 1,000 marks sterling per year. And this is Tomlin's Law Dictionary, Volume 2, under the definition of Pope. And not long after this, by general excommunication of the king and people for several years, because they would not suffer an archbishop to be imposed upon them, King John was reduced to such straits that he surrendered his kingdoms to Pope Innocent III to receive them again and hold them of him under the rent of 1,000 marks. With the concessions of England to the Pope in the year 1213, and, you can look those up. This concessions to the Pope, just do a Google search, and you'll come up with the document. We will, in establish perpetual obligation and concession, we will establish that from the proper and especial revenues of our aforesaid kingdoms, for all the service and customs which we ought to render for them, saving in all times the penny of St. Peter, the Roman Church shall receive yearly 1,000 marks sterling. Namely, at the feast of St. Michael, 500 marks, and Easter, 500 marks, 700, namely, for the Kingdom of England, and 300 for the Kingdom of Ireland, which means the Pope owns the Kingdom of England and Ireland, now known as the United Kingdom, the Crown, and the City of London. Sesquiquet V Act of 1666 caused the War of Independence. The Pope's dependent city-state in the City of London, called the Crown, created the Sesquiquet V Act. So think about you guys in Canada. This is the same stuff that's going on in Canada. Yet still it was found difficult to set bounds to ecclesiastical ingenuity. That's the Pope, folks. For when they were driven out of all their former holes, they devised a new method of conveyance by which the lands were granted not to themselves directly, but to nominal fees to the use of the religious houses. That's the Vatican, folks, thus distinguishing between the possession and the use. And use is short for usufruct under Roman law. And receiving the actual profits while the season of the land remained in the nominal fee, who was held by the courts of equity, then under the direction of the clergy. Isn't that convenient? The Pope gets to run all the courts. That's the same today. To be bound in conscience to account to assist use for the rents and emoluments of the estate. Well, gee, folks, that's taxes. And it is to these inventions that our practitioners are indebted for the introduction of uses, which is short for usufructs, and trusts, the foundation of modern conveyancing. And that's Tomlin's Law Dictionary, 1835 edition, Volume 2, under the definition of mortmain. Who was held by the courts of equity, then under the direction of the clergy. That's the Pope, folks, to be bound in conscience to account to Sesquiquet use for the rents and emoluments of the estate. And that's taxes, which means the Pope clergy were the judges in the ecclesiastical municipal law courts, which is what precipitated the War of Independence, as evidenced by the causes and necessity for taking up arms issued by the Continental Congress in 1775. Statutes have been passed extending courts of admiralty and vice-admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the course of common law, instead thereof to publish the order and use the exercise of the law martial, for altering fundamentally the form of government established by charter. That means Roman law. We saw the misery to which such despotism would reduce us. That's dictatorship, folks. And the organic law, the Declaration of Independence, shows it was listed as reasons for the Declaration of Independence from the Pope's tyrant, the Crown of England. He has combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. Well, think about it. The others is the Pope. And it's Roman law is what they're subjecting everybody with, or were. And they're doing it again today, giving his assent to their acts of pretended legislation. We're going to talk about pretended legislation here in a minute. For transporting us beyond seas to be tried for pretended offenses. Okay, that's all coming from the Pope. For imposing taxes on us without our consent. For depriving us in many cases of the benefits of trial by jury, for taking away our charters, abolishing our most valuable laws, and altering fundamentally the forms of our government. So it's basically dictatorship, folks. He's abdicated government here by declaring us out of his protection and waging war against us. Well, that's what happens when the Pope's involved. Because they say he's combined with others to subject us to a jurisdiction foreign to our Constitution and unacknowledged by our laws. The others is talking about the Pope. And the foreign jurisdiction is the Pope's ecclesiastical Roman civil law. And the preamble of the definitive Treaty of Peace of 1783, King George was Arch-Treasurer and Prince-Elector of the Holy Roman Empire, evidencing that he was authorized to make peace on behalf of the Pope. It was all coming from the Pope. The Pope's Sestake V Act of 1666 was brought into the United States with the Code of Law for the District of Columbia, an act to establish a Code of Law for the District of Columbia, the legal estate to be the Sestake Jus, 31 Stat 1432, which is now codified at 31 CFR 363.6. And the Pope's necromancy, that's the Sestake Jus, which is necromancy. Use is usufruct, and people are presumed dead at chapter 3, absence of 7 years, where it says presumption of death. He shall be presumed dead in any case where his death shall come into question unless proof be made he was alive within that time. The Pope's minor estate, Sestake usufruct, now codified at 31363.6, are unconstitutional because Article 1 of the Amendment requires Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. And the Pope's necromancy, Sestake usufruct, which is now called the minor estate at 31 CFR 363.6, is an entity because an entity includes the estate of a living person, such as an incompetent or a minor. And this is the actual 31 CFR 363.6. Entity means any owner of a Treasury direct account that's not an individual. Entity is a sole proprietorship, partnership, corporation, limited liability company, or professional limited liability company, trust, the estate of a decedent, or the estate of a living person, such as an incompetent or a minor. And a minor can be anyone over the age of 18 years who's failed to take control of the securities in their Treasury direct account. Minor means an individual over the age of 18 years. The term minor is also used to refer to an individual who's attained the age of 18 years but has not yet taken control of the securities contained in his or her minor account. The Pope's pretended jurisdiction. Remember we were talking about that? It's in the Declaration of Independence. When they're talking about pretended jurisdiction and pretended offenses in the Declaration of Independence, and this is where it talks about it, he's combined with others to subject us to a foreign jurisdiction, a jurisdiction foreign to our Constitution, unacknowledged by our laws, giving his assent to their acts of pretended legislation for transporting us beyond seas to be tried for pretended offenses. They're talking about the Pope's ecclesiastical Roman canon civil law. Law canon, the canon of law, body of Roman ecclesiastical law, such relative to such matters as the Church either has or pretends to have the proper jurisdiction over. That's Bouvier's Law Dictionary, 1856 edition, volume 2, page 8. Canon law, or body of canon law, collection of ecclesiastical rules, definitions, constitutions taken from the ancient councils, writings of the fathers of the Church, and ordinances of the popes. The law is modeled according to the form of the civil and contained in 3 particular volumes, the Decrees of Gratian, the Decretals, and the Sextum. And that's 1720 Phillips, the New World of Words, 1720. And there's lots of references in old law dictionaries to the Pope's pretended jurisdiction. Jesuits, this is Jacob A. New Law Dictionary, 1750. Jesuits, born in kingdoms, kings' kingdoms, and ordained by the pretended jurisdiction of Rome, remaining in England and coming beyond the sea into this kingdom and not submitting to some bishop or justice of the peace within 3 days. Okay, and so it doesn't matter what the rest is saying. I wanted to focus on the pretended jurisdiction of Rome. The oath of supremacy is principally calculated as a renunciation of the Pope's pretended authority. And that's Tomlin's Law Dictionary, 1835 edition, volume 2, under the definition of oath. The Pope's Sestake Jus minor estate is a fiction of law which was invented by the Roman praetors under the pretense of doing equity and owe their origin to the legislative usurpations of the bench. And that's Bouvier's Law Dictionary, 1856 edition, volume 1, page 520. And the Pope's fictions of law are necromancy and satanic. And this is the Holy Bible, Deuteronomy 18:10-12. There shall not be found among you anyone that maketh his son or daughter, to pass through the fire, or that useth divination, or an observer of times, or an enchanter, or a witch, or a charmer, or a consulter with familiar spirits, or a wizard, or a necromancer. For all that do these things are an abomination unto the Lord, and because of these abominations the Lord thy God doth drive them out from before thee. And puts you under the Commerce Clause, Article 1, Section 8, Clause 3, in violation of Article 1, Section 8, Clause 17. To exercise exclusive legislation in all cases whatever over such district not exceeding 10 miles square, as may by cession of particular estates and the acceptance of Congress become the seat of government. Fictions of law were invented by the Roman praetors, derogate from law under ecclesiastical canon law for the Pope's ecclesiastical city-states, that's now the Vatican, under the pretense of doing equity. And this is Bouvier's Law Dictionary, 1856 edition, volume 1, under the page 520. Fictions of law were invented by the Roman praetors, who, not possessing the power to abrogate the law, were nevertheless willing to derogate from it. So it's derogatory. Under the pretense of doing equity. Fiction is the resource of weakness, which, in order to obtain its object, assumes as a fact what it is known to be contrary to truth. When the legislator desires to accomplish his object, he need not feign, he commands. Fictions of law owe their origin to the legislative usurpations of the bench. And fictions of law owe their origins to the legislative usurpations of the bench. The fake judge is a legislator when dealing with fictions of law, which means the fake judge's legislative act is a bill of attainder, because a bill of attainder is a legislative act that applied to named individuals to inflict punishment without a judicial trial. And this is United States versus Lovett, U.S. Supreme Court. Bill of attainder means a legislative act, no matter what their form, that apply to either named individuals or easily ascertainable members of a group in such a way as to inflict punishment on them without a judicial trial. And this is Corpus Juris Secundum, Black's Law Dictionary, 8th edition, page 496. Bill of attainder, a special legislative act prescribing punishment without a trial for a specific person or group. Bills of attainder are prohibited by the U.S. Constitution. A bill of pains and penalties is a legislative act, though similar to a bill of attainder, prescribes punishment less severe than capital punishment. So bills of pains and penalties, a bill of attainder is capital punishment. Bill of pains and penalties are included within the U.S. Constitution's bans on bills of attainder. Because judges only hold office during good behavior, both judges of the Supreme and Inferior Court shall hold their office during good behavior. And judges in bad behavior, fake judges, are engaged in fraud upon the court. Fraud upon the court is fraud which is directed at the judicial machinery itself. It is not fraud between the parties or fraudulent documents or false statements or perjury. It's where the court or a member is corrupted or influence is attempted, or where the judges has not performed his judicial function, where the impartial functions of the court have been directly corrupted. Gee, that sounds like corruption. When a superior court of general jurisdiction undertakes anything in derogation of common law, it becomes an inferior court of limited jurisdiction. It is familiar law that when a special statutory authority in derogation of common law, gee, that sounds like a fiction of law, conferred on courts of general jurisdiction, such a court of general jurisdiction becomes quad hoc a court of inferior or limited jurisdiction. All courts are presumed to be a superior court, all superior courts of general jurisdiction are presumed to be lawful courts, okay? So that's what we're talking about there, is a superior court of general jurisdiction, but they are not, okay? Even a regular court that you might think is a superior court of general jurisdiction is, if it's dealing with fictions of law, then it's not. It's not in that for that quad hoc means for the purpose of this proceeding only. Okay, so for that proceeding, if they're dealing with fictions of law, then it's not a superior court of general jurisdiction. A court can be a court of general jurisdiction for some purposes and a court of limited jurisdiction for others. When, therefore, a court of general jurisdiction proceeds under a special statute, it becomes a court of limited jurisdiction for the purpose of such proceeding. And that's Book 21, Corpus Juris Secundum, Court, Section 2. And Book 20, American Jurisprudence, Courts, Section 103. Accordingly, where a court of general jurisdiction undertakes to carry out a special power, a decision made in the exercise of such power is treating as a ruling of a court of limited jurisdiction, and the presumption applicable to a court of general jurisdiction that it acted within the scope of its jurisdiction does not apply. They use fraud and deception to assault people with quasi-contracts, which is a fake contract. A sumpsit, in its origin an action of tort, a sumpsit was soon transformed into an action of contract, being afterwards a remedy where there was neither tort nor contract, based at first only upon an express promise. It was afterwards supported upon an implied promise, and even upon a fictitious promise. These liars just lay awake at night dreaming this shit up. Introduced as a special manifestation of the action of the case, it soon acquired the dignity of a distinct form of action, which superseded debt. Now look at these words are commercial. Okay, you got to understand this is commerce. Superseded debt became concurrent with account, case upon a bailment, warranty, bills of exchange. Those are all commercial words. And competed with equity in the case of essentially equitable quasi-contracts. Both in Roman and English law, there are certain obligations which were not in truth contractual, but the law treats as if they were. They were contractual in law, but not in fact, being the subject matter of the fictitious extension of the sphere of contract to cover obligations which do not reality fall within it, which requires the Pope's fiction of law, minor estate. Quasi-constructive contracts are based solely upon the fiction of law. Because under the Commerce Clause, the boundaries of the Pope's District of Columbia and through their plenary power nationally covers those citizens even when one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. And that's National Mutual Insurance Company of the District of Columbia versus Tidewater Transfer Company, 1948. Which is why in the Kavanaugh hearings, when he was being interviewed for the Supreme Court appointment, they asked him, can we go after a U.S. citizen in Afghanistan? And Kavanaugh said, yes, you can. And because plenary power is a dictatorship under the Pope's Roman civil law, see, says here, through their plenary power nationally. Okay? Plenary power is a dictatorship. Plenary is full, complete. The courts of admiralty and the English ecclesiastical courts, causes or suits in respect of different courts and proceeding in which each is termed plenary or summary. Plenary is full and formal. Suits of those in the proceedings must be full and formal. The term summary applies to those courts where the proceedings are more succinct and less formal. Plenary, a plenary power or a plenary authority is a complete and absolute power to take action on a particular issue with no limitations. It's derived from the Latin term plenus. Plenary power, complete power over a particular area with no limitations. This term is often used to describe the commerce power of Congress. Under the Commerce Clause, Article 1, Section 8, Clause 3, Congress is granted full power over interstate commerce. The court has found that states are not able to pass laws affecting interstate commerce without the permission of Congress. And that's Legal Information Institute. That's Cornell Law School. Oh, thank you. Thank you. Somebody sent me a what do they call those things? It's $5.
I want my cut.
Thank you there very much, Twitch 307. So anyways, I will upload a Word file of this. I'll put a link in the YouTube video if people are expressed an interest in it. And I'll definitely have a Word file that I'll put on the We Are Law, on my We Are Law page. Everything changed, the Pope's private bar guild. Everything changed for the bar and the bar treaty, with the bar treaty of 1947. Did you know there's a bar treaty of 1947? Everything changed around then. The Pope's clergy operate their ecclesiastical Roman civil law courts with a private bar guild, with bar being an acronym for British Accredited Regency. A regency is the office or jurisdiction of a body of regents, a government by authority of regents, a period during which a region or body of regents governs. That's Black's Law Dictionary, 8th edition. Because the Pope's private bar guild clergy members are appointed by Inns of Court. Inns of Court, these are certain private unincorporated associations in the nature of collegiate houses located in London and invested with the exclusive privilege of calling men to the bar. That's Black's Law Dictionary, 5th edition, which is located in a Pope's dependent city-state, located in the city of London, originally called the Kingdom of England and Ireland, now the United Kingdom and the Crown. Since the concessions of England to the Pope, 1213, which means the private bar guild members are foreign agents of the Pope, which is why they're here under the Pope's civil laws of Congress as foundation for the Federal Bar Association under the Code of Law for the District of Columbia, now known as Title 35, U.S. Code 70501 through 70512, claiming immunity under the International Organization Immunity Act of 1945, 59 Stat 669. The demand has filed bar grievances against 98 of the Pope's private bar guilds, some more than once, and they've all been dismissed as an inquiry. They were all appealed to the Pope's Board of Disciplinary Appeals, and they were dismissed again. The demand has filed judicial complaints against more than 50 judges and the State Commission on Judicial Conduct, some more than once, and they've all been dismissed, 25 of them on the same day. There are two national governments, one under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. This is the dissenting opinion of Justice Marshall Harlan in the case Downs versus Bidwell, 1901. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. The Pope now owns and operates the 1871 Municipal Corporation, Ecclesiastical Municipal Corporation, at 16 Stat 419, because when any corporation goes bankrupt, it gets seized by the creditors, as evidenced by the Roman Achaea military staff that's carried in battle by all Roman commands and planted on all conquered nations, that's sitting on the right side of the speaker's podium, and the two Roman fascia, bundle of rods bound into a weapon symbolizing under the rule of a single man, that are on the wall on each side of the speaker's podium in the U.S. House of Representatives, which is also why, as Speaker of the U.S. House of Representatives, Nancy Pelosi told the members, we can't read this bill until after we pass it, because she was taking instructions from her Jesuit handlers, all of which evidences the fact that the 1871 Ecclesiastical Municipal Corporation, 16 Stat 419, currently operating in the District of Columbia, is the Pope's dependent city-state. See image below. And the Vatican's Pope Francis, recently issued an apostolic letter about jurisdiction and judicial authorities. It's called a super chat. They sent me a super chat. Thank you for the super chat. Jurisdiction of judicial authorities of Vatican City, State, and criminal matters, that talks about concurrent jurisdiction in other states, which means other papal states like the District of Columbia and the City of London, United Kingdom Crown. And this is a quote from the letter. When the same matters are prosecuted in other states, the provisions enforced in Vatican City, State on concurrent jurisdiction shall apply. That's all it says. Apostolic letter issued motu proprio, entering into force 1st of September 2013, which means the Pope's ecclesiastical canon law is brought into Texas with the Commerce Clause, Article 1, Section 8, Clause 3, and the Pope's minor estate, fiction of law, and the Pope's fictitious quasi-contract. And there's an image of the Speaker's podium in the U.S. House of Representatives, and notice the two Roman fascias. I don't know if you can see my cursor. I'm pointing out those two, the arrows, the two black arrows are pointing at the Roman fascia, and the Roman Achaia military staff is right here. That's carried by all Roman commands and planted on all conquered nations. And the Vatican's Pope Francis came and addressed his own and operated Congress on 24 September 2015, and the Vatican's satanic private bar guild clergy members are assaulting people like the demandant with their ecclesiastical fiction of law, minor estate, sestike usufruct, trust, necromancy, with presumptions of jurisdiction, presumptions of the office of trustee, because of the sestike usufruct, minor estate, which is a type of a trust, and presumption of suretyship. And but individuals, when acting as representatives of a collective group, cannot be said to be exercising their personal rights and duties, nor be entitled to their purely personal privileges. Rather, they assume the rights and duties and privileges of the artificial entity or association which they are agents or officers, and they are bound by its obligations. That's U.S. Supreme Court, Bresswell versus United States, 1988. Quoting United States versus White, 1944. Whenever the Uniform Commercial Code creates a presumption with respect to a fact or provides that a fact is presumed, the trier of fact must find the existence of the fact unless and until evidence is introduced that supports a finding of its non-existence. The demandant has served literally thousands of registered mail notice and demands in an effort to defeat those presumptions, exercising constitutionally protected rights to seek a redress of grievance, and exhausted administrative remedies, which is why they've targeted the demandant with their targetedjustice.com website agenda. Conclusion. The Pope's, and the reason I do this is because as long as I do a memorandum, I do a motion and a memorandum attached to it. That's under local rules. The memorandum can't have any more than 10 pages. If it has more than 10 pages, then I have to have a table of contents and a list of sites and all sorts of crap. And so as long as I have it under 10 pages, it's relatively simple. Anyways, the Pope's 1871 ecclesiastical municipal corporation operating in the District of Columbia is unconstitutional, as well as the Pope's minor estate, 31 CFR 363.6, and the Pope's private bar guild, because they're all violations of Article 1 and Amendment, because Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof, because they are laws respecting the Pope and the Vatican and the Holy See, and they're subjecting the demandant and all the people they're dealing with to their satanic religious ceremony with their fake ecclesiastical Roman law cases and with their fraud, deception, lies, necromancy, slavery, idolatry, and human trafficking. And so that's why I added in. Remember, I went and told you what I put in here. It's in here too as well. A natural living man living in the republic that fails to be dead or lost at sea have never been dead or lost at sea. That's a little dig on those Baal priests that presumed I was dead or lost at sea. And fails to be a surety or accommodation party, the Pope's minor estate, fails to be representing the Pope's minor estate, have never knowingly or willfully represented the Pope's minor estate. And that's because of this court case right here. Now, this Bresswell case. So I'm not representing their minor estate. And so then it's also here, fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to represent the Pope's minor estate, have never knowingly or willfully represented the Pope's minor estate. And that's the end of that one. So we'll see. I'm laying the foundation so that I can go to the Supreme Court again. If the Supreme Court doesn't accept this one, then we'll go for round 2. And this one's going to be early on. So I might even get a ruling early on because I'm challenging it early on. The Court of Appeals might be inclined to rule in my favor. I mean, but I'm bringing up war crimes, and I'm bringing up about the Republic of Texas. Matter of fact, we're going to go through that one next, about the challenge of the constitutionality of the Republic of Texas being brought into the Union. And so that's going to be the next one. And that's actually an amended one because I already filed one. And so I've got one that I've got sitting here that's amended because
Did you have to shorten it or something?
Well, I added in some stuff. There was some things that I left out. There's stuff that, like the stuff that we're talking about right now, about that I'm not representing the minor estate, that I'm not dead or lost at sea. I've never been dead or lost at sea. You see what I'm saying? I'm putting all that stuff in there, and I'm doing it in every document. And so I'm doing the amended one, and so yeah. So that's why I'm doing that. And I think that this one is going to be like, I really think this is going to be a slam dunk. I'm telling you, this one's pretty good. I kind of like it. Anyways, so we'll see. You know, you never know what happens. There's lots of corruption in the courts, so we'll see. That's all I can say. But I don't see how, once I bring up this stuff, when you guys see it, I think that you'll even agree. I can't understand how Texas could possibly be in the Union. Anyways, so we'll see. There was a guy back in the 90s, his name was Scallion, and he was a futurist. He got these visions of the earth and stuff like that. And he said the United States is going to break up and Texas is going to be the first to go. And maybe this is going to be Texas going. So we'll see. You know, that's all I can say. But they're attacking me because of the Republic of Texas, so I'm put in a position that I have to do something about it. And the Republic of Texas, they're just they're wannabes. They're cowards, basically. They're hiding. They're just, yeah, don't get me going. So
Are they liars? I mean lawyers, or I mean liars?
There you go. Let me go and check YouTube. Good. Okay, looking good. The year of our Lord, yeah, that's an interesting thought. I've done that, but then I thought, you know, when they talk about the year of our Lord, are they talking about, Yahweh, or are they talking about the Pope? You know, I'm thinking they're talking about the Pope. Now, maybe it doesn't matter. I don't know. That's the only thing that makes me reluctant to put that in there. And I could specify year of our Lord and Savior Jesus Christ. I could do that. So yeah, that's something to think about. Anyways, but it's Annum Domini, which is Latin, and which is kind of implying that it's the Pope. So, but good comment. Good comment. I've actually thought about that and given some serious thought. But anyway, so now we're going to go to this notice of constitutional challenge. So this is an amended one. I've already filed one. This is an amended. I got to keep it within 7 pages. So I had to play some little games to kind of scrunch it in. Modify the font, take out spaces, a bunch of things, because there's a lot more material. I had to shrink this down because it would have been more than 10 pages for sure, and that would have caused me a lot of grief having to put in other stuff. Anyways, comes now the demandant providing notice to anyone interested that the demandant is challenging the constitutionality of Texas joining the Union in 1845 as a violation of this Constitution for the United States of America, Article 4, Section 3, Clause 1, which requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what was done, as well as Article 6, Clause 2, the supreme law of the land, because the military occupation is a violation of Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States, which requires the territory of a state is inviolable and may not be the object of military occupation, which was ratified as a treaty and entered into force December 26, 1934 at 49 Stat 3097, as found in the breach attached here too, all of which is incorporated herein by reference in its entirety. I got a
Did you cut out?
Sorry?
I thought you cut out.
I did, but it's because something happened on my phone, and I got to silence my phone so it doesn't disturb me. Somebody sent me a text and I heard it, and so that's why I paused. But so now I silence my phone, so if the damn thing starts ringing, it ain't going to disturb what's going on. Anyways, so sign and seal of red ink under penalties of perjury without the Pope's owned and operated United States. GlennWinningham, House of Fern, demandant sui juris, a natural man living in the Republic that fails to be dead or lost at sea, have never been dead or lost at sea, fails to be a surety or accommodation party for the Pope's minor estate, 31 CFR 363.6, fails to be representing the Pope's minor estate, 31 CFR 363.6, has never knowingly or willfully represented the Pope's minor estate, 31 CFR 363.6, and do declare that I ascribe the foregoing facts, and in accordance with my best first-hand knowledge, such are true, correct, complete, not misleading, the truth, the whole truth, nothing but the truth, before God, angels, and everyone who reads this document as witnesses, pursuant to your rules of evidence. 30th of November, 2025. Fails to be dead or lost at sea, has never been dead or lost at sea, fails to be a surety for the Pope's minor estate, fails to be representing the Pope's minor estate, has never knowingly or willfully represented the Pope's minor estate. You know, the usual stuff. And then certificate of service, I hereby certify I failed to be dead or lost at sea, but have never been dead or lost at sea. I failed to be a surety or accommodation party for the Pope's minor estate. I failed to be representing the Pope's minor estate. I declare under penalty of perjury under the laws of the United States of America that I failed to be dead or lost at sea. I had never been dead or lost at sea. I failed to be a surety or accommodation party for the Pope's minor estate. I failed to be representing the Pope's minor estate. I've never knowingly or willfully represented the Pope's minor estate. And the foregoing is true and correct without the Pope's United States. And again, fails to be dead or lost at sea. Have never been dead or lost at sea. Fails to be a surety for the Pope's minor estate. Fails to be representing the Pope's minor estate. Has never knowingly or willfully represented the Pope's minor estate. Amended brief in support of constitutional challenge. Texas, pursuant to Rule 5, Republic of Texas recognition. President Andrew Jackson officially recognized the Republic of Texas on March 3, 1837, which also recognized by France December 25, 1835, and other nations, including Belgium and the United Kingdom. And demanded has visited the former embassy of the Republic of Texas in Paris, France, that is now being used as a hotel. The fact that the Republic of Texas existed is beyond dispute. This is a quote from the Law of Nations by Vattel. Nation or state is, as been said at the beginning of this work, a body politic or society of men united together for the purpose of promoting their mutual safety and advantage by their combined strength. For the very design that induces a number of men to form a society which has its common interests and which is to act in concert, it is necessary that there should be published and established public authority to order and direct what is to be done by each in relation to the end of the association. The political authority is the sovereignty, and he or they who are vested with it are the sovereign. In the U.S., it's they, because it's we the people, right? And there is no definition of how many people are required to constitute a nation or state, and this is Article 1 of the 1933 Montevideo Convention on the Rights and Duties of States. The state, as a person of international law, should possess the following qualifications: a permanent population, a defined territory, a government, and capacity to enter into relations with other states. That's all that's required. And all the inhabitants of the territory properly included within and rightfully belonging to the Republic of Texas are entitled to the same protection of the law. This is Article 9 of the Montevideo Convention. The jurisdiction of states within the limits of national territory applies to all the inhabitants. Nationals and foreigners under the same protection of the law, and national authorities and the foreigners may not claim rights other or more extensive than those of the nationals. So think about it. That's really common law, and that's why they have to put up a wall. Because once they're on American territory, they have all the protections of the Constitution. If they're outside, they got nothing. Once they're on American territory, they have all the protections of the Constitution. The state of Texas joined the Confederacy and Union in the year 1845. The state of Texas joined the Confederacy and Union under the Articles of Confederation and Perpetual Union, 1781, as evidenced by the Act of Congress at 9 Stat 1, and still exists as evidenced by House Joint Resolution 1, dated 29th of December, 1845. The territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the State of Texas, on an equal footing with the original states in all respects whatever, with a Republican form of government, as found in the Act of Congress, December 29th, 1845, at 9 Stat 1. And it says that the state of Texas admitted at the present session of Congress into the Confederacy and Union of the United States. So that's the Confederacy under the Articles of Confederation and Union. And then the House Joint Resolution, dated 29th of December, 1845, at 9 Stat 108. The territory properly included within and rightfully belonging to the Republic of Texas might be erected into a new state to be called the State of Texas with a Republican form of government. And it goes on, and resolved that Texas shall be one and is hereby declared to be one of the United States of America and admitted into the Union on equal footing with the original states in all respects whatever. Because when one sovereign nation joins another sovereign nation, a treaty of annexation is done. A proposed treaty of annexation was prepared by the Republic of Texas and sent to the U.S. Senate for approval and adoption, which was not approved or adopted, but was shelved. The state of Texas was created under Articles of Confederation and Perpetual Union, 1781, Article 9. Says Canada ceding to this confederation and joining the measures of the United States shall be admitted into and entitled to all the advantages of this union, but no other colony shall be admitted into the same unless such admission be agreed to by 9 states. So that means a House Joint Resolution, which means a House Joint Resolution is all that was needed. Therefore, the state of Texas is a fictitious overlay over the Republic of Texas. The territory properly included within and rightfully belonging to the Republic of Texas, which means the Republic of Texas was not replaced by the state of Texas, and the Republic of Texas still existed in abeyance. It seems to the demand for the state of Texas to join the Confederacy under the Articles of Confederation and Perpetual Union, 1781, with the House Joint Resolutions, perfectly fine. But the preamble of the Act of Congress at 29 December 1845 at 9 Stat 1 says Texas is admitted into the Confederacy and Union of the United States, which is also talking about the Union under the current Constitution, which was in place in 1845. And Article 4, Section 3, Clause 1 requires, but no new state shall be formed or erected within the jurisdiction of any other state, which is what was done. The state of Texas failed to replace the Republic of Texas, and the Republic of Texas was recognized by Andrew Jackson, still existed, and the recognition is unconditional and irrevocable under Article 6 of the 1933 Montevideo Convention on the Rights and Duties of States, that was acceded to by the U.S. Senate as a treaty and entered into force December 26, 1934 at 49 Stat 307, 3097. as supreme law of the land under Article 6, Clause 2. This Constitution and the laws of the United States which shall be made in pursuance thereof, and all treaties made or which shall be made under authority of the United States, shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the constitutional laws of any state to the contrary notwithstanding. In the year 1861, the southern states, including Texas, walked out of Congress, and Congress ceased to have a quorum to conduct business and conduct business. And on the 15th of April, notice the date, the 15th of April, 1861, Lincoln ordered Congress to reconvene under executive authority, with Executive Order Number 1 at 12 Stat 1258, and they've been operating under executive authority ever since. The southern states that walked out of Congress became the Confederate States of America, and the war between the states was started, which eventually ended with an armistice, which is a ceasefire only. All of those people are now dead, but there has never been a treaty of peace. The state of Texas was one of the Confederate States of America, and a technical state of war still exists between the United States and the Confederate States of America because there's been no treaty of peace. In 1863, in the year 1863, Lincoln asked Harvard law professor Francis Lieber to write the law of war for the U.S. Army, which became known as the Lieber Code, which was actually designated General Orders 100, all of which is now included in the United States Law of War Manual that is now a book about 4 inches thick and is part of international law or the law of nations. The current state of Texas is a military government put in place by the United States Army under Article 1, General Orders 100, the Lieber Code. A place, district, or country occupied by an enemy stands in consequence of the occupation under the martial law, the invading or occupying army, whether any proclamation declaring martial law or any public warning to the inhabitants has been issued or not. Martial law is the immediate and direct effect and consequence of occupation or conquest. The presence of a hostile army proclaims its martial law. The fact that there's military troops there is all that's needed. You're under martial law. The military government and martial law continues to this day under Article 2, General Orders 100, Lieber Code. Martial law does not cease during the hostile occupation except by special proclamation ordered by the Commander-in-Chief or by special mention in the Treaty of Peace concluding the war. Because there have been no special proclamations by the Commander-in-Chief, which is the President of the United States, and there is no Treaty of Peace to this date. Under House Joint Resolution 1, dated 29 December 1845 at 9 Stat 108, the state of Texas is required to have a Republican form of government. And it's impossible for a military government operating under martial law to be a Republican form of government, because the military government's a dictatorship, as evidenced by Article 3, General Orders 100, Lieber Code. Martial law in a hostile country consists of in the suspension by the occupying military authority of the criminal and civil law and of the domestic administration and government of the occupied place or territory, and in the substitution of military rule and force for the same, as well as in the dictation, that's dictatorship, folks, of general laws as far as military necessity requires this suspension, substitution, or dictation. Now, they never want you to know you're under martial law, the War of Independence. Remember, I read the stuff about from the cause of necessities for taking up arms. The War of Independence was fought over the imposition of martial law. So they don't want you to know. And that's why this other paragraph's in here. The commander of the forces will proclaim that the administration of all civil and penal law shall continue either wholly or in part, as in times of peace, unless otherwise ordered by the military authority. They always do that, okay? They don't want you to know the changes that are being made, but they make changes all the time, and the changes are not negotiable. It's a dictatorship. Because the Republican form of government requires law of the land, natural law, common law, and political power to be in the hands of we the people as a symbolic military government called a democracy, with all state of Texas employees, including the wrongdoers named herein, being federal personnel as required by the Pope's civil codes, Roman Civil Codes 552 AA 5 USC Section 552 AA 13, which is anyone with a Social Security number. The term federal personnel means officers, employees of the government of the United States, members of the uniformed services, including members of the reserve components, individuals entitled to receive immediate or deferred retirement benefits under any retirement program of the government of the United States, including survivor benefits. For the Pope's 1871 municipal corporation, that's 16 Stat 419, civil law, Roman civil law are convertible phrases meaning the same system of jurisprudence, that rule of action which every particular nation, commonwealth, or city has established peculiarly for itself, more properly called municipal law. Black's Law Dictionary, 4th Revised Edition. That exists today is the second national government talked about in the dissenting opinion of Downs versus Bidwell, 1901, that is maintained by Congress outside and independently of that instrument, which is the Constitution. Two national governments exist, one to be maintained under the Constitution with all its restrictions, the other to be maintained by Congress outside and independently of that instrument. And is the Pope's military dictatorship, plenary power, because the boundaries of the District of Columbia expands for the purpose of regulating its citizens wherever they go throughout the states of the Union, and this is through their plenary power nationally, covers those citizens, even in one of the several states, as though the district expands for the purpose of regulating its citizens wherever they go throughout the states of the Union. That's National Mutual Insurance Company versus Tidewater Transfer Company. Therefore, the Pope's owned and operated United States has failed to provide a Republican form of government as required by Article 4, Section 4, except that the Republic of Texas is the Republican form of government. The military occupation is illegal under Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States. The contracting states definitely establish as a rule of their conduct a precise obligation not to recognize territorial acquisitions or special advantages which have been obtained by force, whether this consists in the employment of arms or threatening diplomatic representations or in any other effective coercive measure. The territory of a state is inviolable and may not be the object of military occupation, nor of other measures of force imposed by another state directly or indirectly or for any motive whatever, even temporarily. That's Article 11 of the Montevideo Convention, which requires that the territory of a state is inviolable and may not be the object of a military occupation. Because the 1933 Montevideo Convention on the Rights and Duties of States was ratified as a treaty and entered into force December 26, 1934 at 49 Stat 3097 as supreme law of the land under Article 6, Clause 2. Therefore, it's another violation of the Constitution. After the war between the states and its armistice, many years have passed and all those involved and both sides are now dead. And in the early 1990s, some of the people of Texas, after reviewing the Act of Congress 9 Stat 1 and the resolutions, House Joint Resolution 8, March 5, 1845, 5 Stat 797, and House Joint Resolution 1, 29th of December, 1845, 9 Stat 108, of the U.S. Congress and other historical evidence, discovered that the state of Texas is a fictitious overlay over the Texas territory, which is properly included within and rightfully belonging to the Republic of Texas, over the Republic of Texas, which was in abeyance or dormancy, and brought the Republic of Texas out of abeyance by organizing a provisional government of the Republic of Texas and peacefully held elections, and have been peacefully holding elections ever since, to peacefully provide common law remedies for the people of Texas. The Republic of Texas is a group of men and women on the territory properly included within and rightfully belonging to the Republic of Texas, trying to peacefully bring common law remedies to the people of Texas as a Republican form of government, because the state of Texas is a military government operating exclusively under martial law as a military dictatorship, and the District of Columbia, and can never be a Republican form of government. Even though the demandant has resigned as a senator, the demandant can say with some authority, after being involved with the Republic of Texas government for almost 20 years, that the people of the Republic of Texas would very much like to enter into a treaty of peace with the United States to bring an end to the war, to bring to an end the war between the states as far as Texas is concerned. We believe it would be good for everybody, and maybe other states formerly part of the Confederate States of America would like to do the same. It would be very good to bring that dark chapter of our history to a final conclusion. In the year 1995, the Supreme Court of Texas dismissed Case 95-1002 involving the people of the Republic of Texas for lack of jurisdiction. Styled in re, the people of the Republic of Texas, by and through Richard L. McLaren, their legal diplomatic representative as acting ambassador and consul general and legal affairs officer for the Territorial Land District of Tao, evidencing that they have no authority over the people of the Republic of Texas. Right to self-determination and political status. The U.S. Congress and the President of the United States have acceded to the International Covenant on Civil and Political Rights, 9 June 1992, as now the supreme law of the land as a treaty under Article 6, Clause 2. And we, the people of the Republic of Texas, have the right to self-determination and the right to determine our own political status as Texas nationals. For our Republican form of government guaranteed under Article 4, Section 4, since the Pope's owned and operated United States has failed to do so. Martial law caused the War of Independence. The War of Independence was fought over the imposition of martial law as found in the Cause of Necessities for Taking Up Arms issued by the Continental Congress in 1775. Statutes have been passed extending courts of admiralty and vice admiralty far beyond their ancient limits for depriving us of the accustomed and inestimable privilege of trial by jury in cases affecting both life and property, to supersede the courts of common law and instead thereof to publish and order the use and exercise of the law martial, and for altering fundamentally the form of government established by charter. We saw the misery to which such despotism would reduce us. And that's causes necessities for taking up arms. To supersede the course of common law and instead thereof to publish and order the use and exercise of the law martial. And I've talked about this on numerous occasions. You cannot mix your law. And that's a good example right there, that martial law supersedes and replaces common law, as evidenced by the organic law and the Declaration of Independence, which is a list of grievances against King George. He's combined with others, the Pope, to subject us to a jurisdiction foreign to our Constitution, Roman canon law, and unacknowledged by our laws, giving his assent to their acts of pretended legislation from the Pope, for transporting us beyond seas to be tried for pretended offenses from the Pope, for imposing taxes on us without our consent, for depriving us in many cases of benefits of trial by jury. He's abdicated government here by declaring us out of his protection and waging war against us. And King George even signed the definitive Treaty of Peace of 1783 as Arch-Treasurer and Prince-Elector of the Holy Roman Empire, all of which evidences the true enemy being the Vatican. And the same things are happening in this case today. For all the foregoing reasons, the demandant hereby provides notice that he's challenging the constitutionality of Texas joining the Union in 1845 as a violation of this Constitution for the United States of America, Article 4, Section 3, Clause 1, which requires, but no new state shall be formed or erected in the jurisdiction of any other state, which is what happened, as evidenced by the Act of Congress, December 29, 1845, 9 Stat 1, and in House Joint Resolution 1, dated 29th of December, 1845, at 9 Stat 108. The territory properly included within and rightfully belonging to the Republic of Texas was erected into a new state to be called the State of Texas, as well as the fact that the U.S. Army State of Texas Municipal Corporation and the military occupation are unconstitutional because of Article 11. So notice the U.S. Army State of Texas Municipal Corporation and the military occupation, because of Article 11 of the 1933 Montevideo Convention on the Rights and Duties of States, which is the supreme law of the land under Article 6, Clause 2. This court has no choice but to declare that the U.S. Army State of Texas Municipal Corporation is illegal and unconstitutional, and so is the military occupation. And Mike Blackwell is the president of the Republic of Texas that has been here since 1836. Signed and sealed in red ink on the land under penalties of perjury without the Pope's owned and operated United States. And again, a natural man living in the republic that fails to be dead or lost at sea has never been dead or lost at sea, fails to be a surety or accommodation party for the Pope's minor estate, fails to be representing the Pope's minor estate, has never knowingly or willfully represented the Pope's minor estate, and declare that I have scribed and read the foregoing. Failed to be dead or lost at sea, has never been dead or lost at sea, fails to be surety for the Pope's minor estate, fails to be representing the Pope's minor estate, has never knowingly or willfully represented the Pope's minor estate. Anyways, that's the end of that one. Does anybody have any questions? Now is a good time to have a question period.
I do, but I'll let anybody else go first.
You'll let who?
Whoever wants to go first, go for it.
Oh, okay.
No takers? Okay. I have a question. So, why aren't you using a notary to send this for you and to certify your signature?
Well, I filed a lawsuit, and under the rules, all I have to do is make it under penalty of perjury. I don't need to see here, under penalty of perjury. So all I have to do is make it under penalty of perjury. I don't need to use a notary. Notaries cost money, and it's a nuisance having to hunt one down every time. And so all it has to be is under penalty of perjury. And so that's the way I do it. I'd have to make that statement anyways, whether I use a notary or not. So it's just extra money and extra hassle.
Okay, there's some speakers on here that occasionally mention the direct stamp. Can you speak on that a bit?
The what?
It's vitally important, apparently. Maybe you want to mic up so everybody doesn't get it back.
Sorry? You want me to mute?
Maybe, yeah, for just a sec. There's some speakers on here that talk about the direct notary stamp is vital to any court case. Can you speak on that at all? Do you know what it is? Because I don't.
I don't know what it is. I haven't heard of that. I'd be willing to look at it, but other than that, I haven't heard it.
Okay, fair enough. Thank you for answering.
Okay, so this is a Form 211. So we'll go through this right now. I'm not going to go through everything that I attached. I attached some documents. I'll just go through, and this is my first crack at this, so it's not like I'm, an expert.
Don't doubt yourself. We don't know any different.
There you go.
I just know that form is vital in the identity theft cases.
Right, it's part of it. Yeah, this is a IRS form, and I mailed it to IRS today. And this is what I mailed them. Now, I've actually been given some ideas on some other stuff that I can do as well. So I got to look into that.
Did you put a timesheet along with it and a cover letter?
Nope.
That's what I've heard is necessary.
You heard what?
I've heard that's also necessary, but I'm not an expert either, so it's always a good idea to write a cover letter.
Okay. Well, I didn't. I think it covers it by itself. But, there was no, like, there's a book, actually, an IRS publication, 5251, that's instructions on doing this form. And so I don't remember seeing in there anything about a cover letter or anything like that. So, anyways, so this is the Form 211. And so you basically ought to check all the boxes that need to be checked. And so I am including attachments, and it's not an existing claim, and I haven't submitted it to anybody else. And I added, what I named is the 45th District Court is the taxpayer, the corporation. And then I also added Stephen Jooms, who's the judge of that court, Phil Sorrells, that's the district attorney, Thomas Wild is the court clerk, Elizabeth Beach is a judge of another court, Leah Simonton is the U.S. attorney or former U.S. attorney, Marshall Thomas is Montague County Sheriff, Michael Lugo, Hal R. Ray is federal court magistrate judge, Reed O'Connor is the chief judge of the Northern District, Karen Mitchell is the clerk of the Northern District, R. Joseph Rothrock is the FBI special agent in charge, Sam Bregman is district attorney in Albuquerque, Joshua Sanchez is a judge, chief judge, Militia Dowler is another judge in Albuquerque, Alan Wayland is the Grapevine magistrate, Bill Wayborn is the Tarrant County Sheriff. So there's how many people added? 2, 4, 6, 8, 10, 12, 14, 15, 16. So says, what's your relationship? Do you still maintain a relationship? No. I was defendant for 3 felonies with a $500,000 bond, and when I exposed that the warrants failed to be authentic, they dismissed all of the charges, evidencing it was a malicious prosecution. So there unreported or underreported income, specific allegations of tax fraud, overstated or false deductions, failure to withhold tax, failure to file tax information return, failure to pay the tax, tax exemption, government entity tax issue, terrorism. And so aggravated identity theft, accounting fraud, concealment, securities fraud, tax evasion, embezzlement, and forgery. Describe the alleged violation. I believe they're involved in aggravated identity theft, accounting fraud, concealment, securities fraud, tax evasion, embezzlement, and forgery. I believe they forged my signature onto a 1099A as well as bid performance and payment bonds. I believe they concealed the accounting and the bonds with the intent to defraud me. I believe they embezzled money from the minor estate treasury direct account, 31 CFR 363.6. They charged me with terrorism and then dismissed all charges against me and several others when I exposed the warrants that failed to be authentic, which means it was a malicious prosecution. They're actually the terrorists. When confronted about the accounting, they claimed ignorance. Is this based on public information? Yes. I believe they forged my signature onto a 1099A as well as bid performance and payment bonds to embezzle money from my minor estate treasury direct account. I do not have them. They're wanting to know if I have the copies of the documents. I do not have them, but there should be entries in the Treasury Direct account, and a forensic accountant can find them. Describe how you learned. 26 U.S.C. 7302, 7201, 7602, and 676. Warrants for arrest that failed to be authentic, and fugitive complaints that claimed they would use the Social Security number and date of birth to identify me for extradition, evidencing they're accessing the Treasury Direct account. There was a $500,000 bond that described the amount of tax owed. I don't know, but I can tell you there was a $500,000 bond that I know about. I've attached copies of the warrants in the fugitive complaint used when they extradited me from New Mexico. I've also attached a motion to quash the warrants that I sent to the court-appointed attorney before the case got dismissed. They're required to pay a 20% tax on the proceeds, which brings up the tax evasion, the issue of tax evasion. So if tax years 24 and 25, and then that's my information, and that's a bunch of questions they asked me that I answered, and we won't show that stuff anymore. And so then this is the fugitive complaint. Anyways, okay, so that's about it. Does anybody have any questions about that Form 211?
So that's for the audit, right? Audit the account that the,
Well, it's what it is a whistleblower form. So what happens is the IRS will investigate it, and if they get any money, if they find out any information and get any money, then I'll get a percentage of whatever they get. It's I think the maximum of 25%. I don't know what it is. Depends on what happens and all the rest of it. But it's a whistleblower form, so I'll get a percentage of whatever they get.
No problems with mailing or anything? You've been able to get that through? No problems with mailing at all, I've heard earlier.
No. Okay, I just uploaded those constitutional challenge briefs and notice a constitutional challenge to my page on the Weir Law. And let's see now. We also wanted to go through the what else? Oh, I know what.
Electric filing demand.
Right. Yeah, I'm looking for it. Notice of objection to the electronic filing stand.
Chevy, did you have a question?
I was just gonna ask how these courts, when they file the 1099, are they using our exempt account? So, I mean, they're claiming to be us, they're forging our signature. Are they using our exempt account? Because it doesn't ever really come back that we owe that for that court case, so we don't ever know what taxes were evaded through the courts acting as us. If that makes any sense? So are they using our tax exempt account so we're not notified that, hey, you had a $5,000 gift that you owe taxes on, that we, or whatever, 1099, whatever the case may be, that you owe taxes on because you gave this court $5 million, you owe taxes on it. So that they have to be using our exempt account because we're never notified of that, right?
Well, they're supposed to. No matter what, they're supposed to notify you, and so it's still a problem. They're supposed to notify you, and you're supposed to be signing those documents. What they do is they just print your signature. There's a video that I uploaded to the group. Let me look. I uploaded it to the group a week ago or 2 weeks ago.
So what I'm trying to, I guess, if the courts are putting in these 1099As, IRS, Treasury, whoever, they know that it's not from us. They know that we're not filing those and sending them in. Obviously,
Well,
it's not
it's
taking
got
them
your
to
name on it. It is your document, and it's got
I
your
know, honey,
name
I
on
know,
it.
but
So it's coming out of
they
your
know that
account.
it's the courts that are writing those. It's not anything to do with the
If
plaintiff
you
or
go
the
through on
person
the
writing.
on the 14th of November, I uploaded a YouTube video called "The Secret Financials Underlying Our Justice System" with Todd Duell. I would suggest you watch that video, and then you'll understand exactly what's going on.
I was
That's
going to
on
ask
the
about the OID. When
that's on my page on 14th of November. I uploaded the video. I put a link. Actually, it's just a link, but you can go there and open that video up. Click on the link, and it will tell you everything you need to know. That's where I'm getting that information, is from that. He tells you the forms to use. The 211 starts it all, and he explains it. Matter of fact, I also uploaded notes. There's a file called Notes that is notes that I took while watching that video that you can use. You're welcome to use it, and maybe you want to add some more notes. It's up to you. But I would suggest you watch that video, and then you'll know, and there won't be any discussion here because you'll know about it. Anyways, this is a notice. This is a notice of objection to the District of Columbia electronic filing. You got the filing stamp right there. And so what they did is they sent a document telling me, the clerk did. It wasn't even signed by a judge, actually. But I did this last time, and it was crickets. Never heard another word about electronic filing. And I've actually had cases dismissed because I didn't do electronic filing. And so this nips it in the bud. Notice of objection.
That's so strange because I've literally had where they told me that I couldn't electronically file.
Well, I don't know where you're at, but I can tell you in Texas, all the courts do electronic filing, but it's not mandatory. But in the federal court, I had a case dismissed because I refused to do the electronic filing, and
That's so
I should
interesting.
probably sue the judge over that. But whatever. But so they all do electronic filing. It's for the lawyers, really, is who it's for.
Right.
But they like to assault all sorts of people with it. And so I just automatically respond. And this is my response. Notice of objection to the District of Columbia electronic filing. The demandant will gladly do electronic filing when this court provides their statutory and delegated authority to compel the demandant to do the electronic filing, and this court provides an order signed by a judge acting as official capacity with a court seal on it that the demandant apply for and get a social security number and get 2 forms of government issued identification, then get a bank account, and then get a debit card for the electronic filing, all of which falls under the Pope's Roman canon law. And this court's providing an Article 4 and Amendment warrant signed by a judge acting in his official capacity with a court seal that orders the demandant to disclose all or part of a social security number, disclose the debit card number, disclose the name, disclose an address, disclose the date of birth, disclose 2 forms of identification, disclose anything else to the electronic filing system that's required, calling out specifically what has to be disclosed as required by Article 4 and Amendment for the Social Security number, the bank account, and their electronic filing. And that's it. That's like a 2-pager. Yep, that's what it is, a 2-pager. And so then that's before I had the new signature line. So there's not as much stuff there. But anything in the future is going to have all that stuff that we just saw in my other documents. And this is a certificate of service, and that's it. And then the notice of objection to the District of Columbia, the interrogatory, impecuniosity interrogatory. That's an impecuniosity interrogatory, right? They give you a questionnaire. And if you wanna, they're gonna. You don't want to pay the filing fee. They say you're accuse you of being a pauper. And they give you
You're
this questionnaire.
poor.
Sorry?
They call it a waiver here.
Call it a what?
A waiver. But yeah, it means the same thing. You're a poor man. A peon.
Yeah. So anyways, this is my answer. If this doesn't work, I think it's gonna, okay, because they never want to answer this kind of stuff. I think it's gonna. But if it doesn't work, then I'm going to send them 400 grains of rice. There's a friend of mine that did that, and it worked great. So that's plan B. So, but I think this is going to work. As you can see, it's filed. Notice of objection to the District of Columbia informa pauperis interrogatory. And that's what it is. It's an interrogatory. The demandant will gladly complete the informa pauperis interrogatory when this court provides their statutory and delegated authority to compel the demandant to complete the informa pauperis interrogatory, and this court provides an order signed by a judge acting in his official capacity with a court seal on it, ordering the demandant to apply for and get a Social Security number, get 2 forms of government-issued identification, get bank accounts, call the girl to whom he's joined in holy matrimony a spouse, call his property assets, call his sons and daughters children and dependents, call his source of compensation for labor his employer, call his private automobile a motor vehicle, call his compensation for labor gross monthly pay and income, call the land he owns an asset, call his traveling transportation, call his home a legal residence, call the money he spends expenses, for the informa pauperis interrogatory, all of which falls under the Pope's Roman canon law, and this court provides an Article 4 and Amendment warrant signed by a judge acting in his official capacity with a court seal that orders the demandant to disclose all or part of the Social Security number, disclose financial institutions, disclose income, disclose spouse income, disclose gifts, disclose spouse gifts, disclose retirement income, disclose other income, disclose the demandant's age, disclose employment history, disclose spouse employment history, disclose employer address, disclose expenses, disclose assets, disclose a legal residence, and disclose anything else that's required to be disclosed, and calling out specifically what is required to be disclosed as required by Article 4 and Amendment for the informa pauperis interrogatory. Sign and seal in red ink under penalties of perjury without the Pope's United States. And that's it. This is a 3-pager. It's a little bit longer. Actually, it's 4 pages with the certificate of service. But that's filed too. And so I expect that I'm going to go there on Monday, and they're probably going to be, I'm going to take a bunch of summonses, and hopefully the clerk will go ahead and stamp those summonses, and I can start serving these things. So we'll see. If not, we'll go to plan B. I'll mail them by certified mail, 400 grains of rice. Does anybody have any other questions?
Yes, Tori has a question. Go ahead, Tori.
Well, I didn't have a question. I just thought I got muted.
Oh, you had an open mic, and Glenn was going through the documents so we could hear your back sound. Sorry about that.
I dropped they're committing Sarbanes-Oxley violations by not giving you the gap accounting. I dropped the form for the Security Exchange Commission to report what they're doing, and it comes from Todd off his site.
Yeah, Todd's a brilliant guy. Drop it. What do you mean drop it?
I put it in the room. Put it in the general discussion room at the bottom.
Oh, the form.
With the form.
I put it on my page. You can find it on my page. It's called Notes. It's a file called Notes on my page. Let me look here. I'll show you I'll tell you where I uploaded it. It's on my page.
Oh.
It's uploaded on the 14th of November.
That's the TCR form from the Security Exchange Commission?
Just says Notes.
I got it. This is the Security Exchange Commission to report them what they're doing. with using the security exchange.
Oh, really?
Complaint tip.
What's the name of that form?
I dropped it in there at the bottom of the discussion room right here.
Of my room or the main room?
In the
general discussion we're talking in right now.
Yeah, in the general.
Okay, let me see.
It's form TCR form.
General open
complaint
discussion.
or referral.
There we go.
United States Security Exchange Commission.
I'll move it later into your room, Glenn. Do you see it?
Well, I'm looking in the general discussion room now, general open discussion, and I'm not seeing that stuff.
Go to the very bottom.
Well, I'm at the very bottom, and it says Republic cannot be restored until 110 of the eligible voters have done the amnesty oath to pay.
That's not the very bottom.
Well, it's as far down as mine goes.
That's strange. I'm looking at it.
I know, it's kind of weird. I agree. I'm not doubting what you're saying. There's something could be some operator error going on here.
Okay, hold on.
Anyways, if Lori will put it in my group, then that'll be perfect, and I'll get it from there. I know where to find it from there. Anyways, anybody else have any questions?
Yeah, I was doing the link.
Okay, there it is. Sorry, I did put it in the wrong room. Now at the bottom.
Okay, and I'll forward it to Glenn's room now.
Okay.
All right, sounds good.
Is the court or bank refusing to turn over the certified GAAP GAAS accounting for the securities and the bid, performance, and payment bond? If yes, revoke, revest, blah, blah, blah.
I think I found it.
Okay. It was a trick finding the form, the actual SEC form.
It goes to LinkedIn?
Well, the bottom one, but I'm saying right there underneath the form TCR tip complaint referral, that OMB control number, OMB report, right above the referral to LinkedIn. Or the link at the bottom. Form TCR form. Anyway.
How do I download this thing? Oh, there we go. All right, I got it. Perfect. Thank you very much.
Violating Sarbanes-Oxley is a huge no-no.
Yeah, no joke. All right. So any other questions? I got it. Thank you very much. That's great. Other than that, I suppose we'll wrap it up.
Yeah, I don't got any bad jokes tonight. Sorry.
Okay. Well, thanks for.
I could update you on.
Thanks for watching.
Thanks for your time. I appreciate you reviewing everything for us and updating us on the cases.
Yeah,
I hope that you don't have to go to Plan B and go to any more expense.
I uploaded Word files of those 2 documents we went through. So if anybody wants to use them, you're welcome to.
Jesus, like they wanted to know everything, on that information sheet.
Well, that's all that stuff is in those forms. In that it's a 5-page form. It's all sorts of crap. And so I figured I'd throw it all in there. Anyways,
good idea. I like that.
Thanks.
So I don't have any bad jokes for you tonight, but will you be back next week?
Yep. Same time, same place, same channel.
Okay, that sounds good. I'll be here.
All right. See you guys next week.
Okay, take care. Have a good weekend.
I will. You bet. Take care. Thanks for everything, and we'll see you guys next week.
Okay, take care.